So it used to be that mediation only happens in phase 2, meaning in the litigation phase of the case. Nowadays, probably since 2017 moving forward, I'm seeing a lot more mediation being done in pre-litigation, meaning before filing a lawsuit. Now, let's talk about what is mediation. Mediation is basically where both sides, the plaintiff and the defendant, hire a neutral third party agreed upon by the plaintiff and the defendant. Neutral third party can be an attorney, it can be a judge, it can be someone that both sides agree to try and mediate the case. They're neutral, and their job is to try and get to a number that both the defendant and the plaintiff can agree with and walk away to try and buy their peace so that they don't spend any more money or time on the case. Mediation is a very effective tool to try and resolve the case, but you have to properly prepare for a mediation. You got to make sure you do everything possible as if you're going to trial to prepare for that mediation to get the best possible outcome. And make sure your attorney submits the mediation brief to the mediator at least 30 days in advance of the mediation so that they can talk to the defendant to try and let them know how much money you're demanding. Because you don't want to walk into a mediation and that's the first time that you're asking the defendant for $500,000. They're not going to give you that money. You have to tell them months and months in advance. Insurance companies, like I said before, they're fear-based organizations. You have to give them time to digest the information. They are huge. They have a lot of bureaucracy. They have to get approvals before they start handing out settlements. So make sure your attorney gives the other side sufficient time to get the money, the authority for the case in preparation for the mediation. I like mediation. I think it's a great tool to try and get cases resolved for everyone to buy their peace and for the case to resolve amicably without unnecessary costs and expenses.